Good morning, good evening, good afternoon, good morning, everyone. And welcome to today's webinar, Student Visa Challenges, hosted by American Telugu Association. My name is Narasimha Chittaluri, and I'm Student Services Chair from American Telugu Association. We know many of you are joining us today with concerns, questions, and a sense of urgency. And American Telugu Association understands the pain. We have brought together expert immigration attorneys to help you understand what is happening and what steps you can take if you or someone you know has been affected. Before we begin, just a few housekeeping notes. This session is being recorded. And please post your questions on YouTube comments, and we'll make sure that we bring your questions to our guest speakers. Let's begin. Before we open it to our guest speakers, I will ask our President, Jayan Challa Garu, to say a few words. Then we will move on to our guest speakers, Prashanthi Reddy Garu from Law Offices of Prashanthi Reddy, and Santosh Somireddy Garu from Somireddy Law Group. But before that, I'll ask Jayan Challa Garu to say a few words. Thank you.
Welcome everyone. Good evening for the students in the US, and good morning for all the parents watching from India. Andarki namaskaralu. The American Telugu Association is always there to support the community. ఎటువంటి ఛాలెంజెస్ వచ్చినా, ఎటువంటి కష్టాలు వచ్చినా కమ్యూనిటీకి అమెరికన్ తెలుగు అసోసియేషన్ ఆట ముందంజలో ఉంటుంది. We understand right now some students are facing challenging times with the service revocation. So we are bringing this webinar. Our goal is that this webinar will provide useful information for the impacted students so they can take appropriate action in the right course of decisions as they think about this service issue. I thank our partners, Somireddy Law Firm and Law Offices of Prashanthi Reddy, for providing this webinar. They are leading this fight from the front, and I'm sure they will give very valuable information to everyone. Thanks to Student Services Chair Narasimha Chittaluri and the entire ATA team for bringing this webinar in a short time. Thanks to ABR Productions for helping with the technical logistics of this program. With that, I'll just go back quickly to Narasimha Chittaluri to introduce panel speakers, and so we can start the program. Thank you, everyone.
Sure. Thank you, Jayant Garu. And I'm honored to introduce today's panelist, Attorney Prashanthi Reddy Garu from Law Offices of Prashanthi Reddy, and Attorney Santosh Somireddy Garu, and Attorney Vijay Reddy Garu, and Gopal Garu from Somireddy Law Group. They are experts in they have handled many complex immigration cases, and I'm sure we'll all get many valuable insights from this session. Thank you all for being here. I will now hand it over to Prashanthi Reddy Garu to say a few words.
Hello, everyone. First of all, I'd like to thank Jay Garu and his entire team for organizing this at such short notice. We all know that there is a lot going on with students. I'm sure Santosh and I, both of us, we are both receiving phone calls, pretty much many phone calls every day from the last 10 days. And we are trying our best to help, the students in the best possible way. And so I'm very happy that ATA has taken this initiative to organize this in such short notice, and we'll be happy to answer any questions. And I think we should just straight away start off with the webinar.
Thank you. Thank you, Prashanti Garu. Sumireddy Garu, would you like to say a few words before we open it to the Q&A?
I would like to thank ATA team for arranging this session in such a short notice. And I'm sure like ATA has ATA has been doing a lot of community service to the Indian diaspora in the US, and they'll continue to do so. I'm very happy to be part of this organization.
Thank you. Thank you, Sumireddy Garu. And now I would request Gopal Garu to coordinate the Q&A session. Please post your questions on the YouTube comments, and we'll get it to our panelists.
Yep. Thank you, Narasimha Garu, and thank you, ATA. Good morning, Santosh sir, and good evening, Prashanti ma'am. So the first question to Prashanti ma'am is, what are the most common reasons service records have been terminated right now?
Right now, what we're seeing with reference to service terminations is anybody who has been fingerprinted with law enforcement. I see that as the most common reason, but also people who've had their CVIS terminated at some point in the past and filed for reinstatement. And even though they've gotten back into status, I'm seeing service terminations there also. With reference to being arrested, it's mostly petty offenses. It's DUIs, shoplifting, mostly traffic violations. In some instances, they've been convicted of misdemeanors. In some instances, they've only been arrested and there was no conviction at all. In some instances, there's no explanation as to why they received a CVIS termination. So we are seeing a mixed bag of cases, but I can tell you 100% it's not people who are felons. So if someone is saying that they're wrong, this is regular students who are maintaining their status in the best way that they possibly can. And even if they have made some mistake, pretty much the mistake was, it was a mistake. It was not something that, it was not a theft or robbery or, in most instances that I see, they were driving, they got into an accident, they were driving by, because their insurance had expired. There are many instances where that has happened. Instances where they were speeding and they didn't realize that a cop was following them until, some 5 minutes later. And so they put them, arrested them for that purpose because they didn't stop when the cop asked them to stop. Oftentimes we see that these students are, we know that students are new to the country and they don't know a lot about driving in the US. And, they commit these silly mistakes, and unfortunately, but the mistake they committed is not, compared to the punishment that they're receiving. There's no comparison between the mistake that they made and the punishment that they're receiving. So that's, what I have to say with reference to people who are getting STEM terminations, CVIS terminations.
Santosh sir, you have a question now. What immediate steps should a student take if they receive a termination notice, and can a student apply for a reinstatement?
It's a good question. So if a student's visa is terminated, they have to worry, but not so much, because visa is something that they need only for traveling. But if the student's service is terminated, then they have to be very careful, because they are considered to be out of status from the day their service has been terminated, right? So technically, they have two options. Option number one is to leave the country, go for visa stamping, and then come back in. Option number two is to apply for reinstatement and also litigate the matter in the court. The problem is that if each of these options have their pros and cons. So for the first option, which is attending visa in their home country coming back, right? Not everybody can do that. Not everybody is willing to do that one. Especially, this may not be a good option for people who are being convicted of a crime, or maybe those people who actually have a pending case in the court, right? Because if they leave the country while the case is still pending in the court, unless a judge has issued an order, it could be a problem for them, right? Second thing is, if they travel to their home country, the chances of coming back could vary, right? Especially if they have been convicted of a crime, especially those involving crime involving moral turpitude, right? So second option is applying for reinstatement, right? But with the challenges with reinstatement is that we don't know how long the processing time would be. Previously, we used to file like maybe 1 or 2 reinstatement applications per month, but now USCIS would be flooded with hundreds of these reinstatement applications, right? Previously, they used to review it in 7 months, but now I don't know if that they'll be able to review it in 1 year, 2 years, we never know, right? So until the reinstatement is approved, you cannot, your service will not be reinstated, and you cannot study or you cannot work. So most of these students are in their early 20s, and then they'll be wasting all their precious time just sitting idly while the reinstatement application is still pending with USCIS. The other problem is, based on the information that we received from a NICE officer, they are not going like, so they still have the ability to arrest somebody until their reinstatement is approved. So until the reinstatement is approved, they don't consider the person to be in status, so they can still arrest and detain an individual whose application is still pending with USCIS. The faster approach for this one is to parallelly file a lawsuit in the court, so that at least you can get a temporary restraining order. So that is the reason why we have been advising students who cannot leave the country to file for both reinstatement as well as a lawsuit in the court.
Okay. So Prashanti ma'am, there is a question we started getting from the YouTube and other channels. I am seeing some attorneys are recommended service reinstatement. What are the grounds for this, as the agency itself terminating saying some violation? And also continued with that question, can we do both lawsuit and service termination together? If service termination is not approved, the entire time will considered as out of status.
Right. So there are 2 things here. One thing is when you do reinstatement, you have to think of unlawful presence, ULP. So basically, unlawful presence, it's tricky because it, in my opinion, it will start as soon as CVIS is terminated. And filing for reinstatement does not stop the clock of, the unlawful presence. Just to give you quick info on what is unlawful presence, if you stay out of status for more than 6 months, then you are barred from re-entering for a period of 3 to 10 years, depending on how long you stay out of status. So if you leave and then try to come back, then you'll be barred from coming back, right? So that is what unlawful presence is. So that's another thing that we have to keep in mind, and not just being out of status. So I'm telling clients to be careful of that 6-month mark. If reinstatement gets approved, it's fine, because then there's no issue with reference to unlawful presence. But if it doesn't, then we're in trouble. So I'm asking students to keep in mind that 6-month marker and figure out what they want to do before the 6 months is over. Hopefully, Santosh will file a litigation lawsuit for them, and hopefully it'll get approved, and then they don't have to leave. But if they do have to, then keep in mind that 6-month marker, right? The other thing I wanted to bring to your attention is that once you file for reinstatement, it is possible to go to school as long as you are enrolled for, again, a full course of study. So colleges are allowing you to go back to school and study. You can't go back to OPT, but you can go back to school, enroll in school, and continue your classes. And colleges are allowing you to do that. But is that useful? Does that help in the sense that if ICE comes to pick you up, will that help? I don't think it really helps. So, maintain a low profile is my advice. But what was your other question with reference to reinstatement? It said that what are the options for reinstatement, right? Or what are the,
Exactly.
okay, on what grounds can reinstatement be approved is, I think, what the question was.
Yes, ma'am. Yes.
Generally, when we file reinstatement, we'll say it's basically you're asking for forgiveness on humanitarian grounds. You have to usually admit the mistake and say that, look, we didn't realize that this mistake was made unknowingly, blah blah blah, and Based on that, we're asking for forgiveness. We have good moral character, get some affidavits, show that they've never been out of status or never been in any other trouble with the law. Get a letter from the school, get a letter from the professor, from the neighbors, from the friends saying that they're outstanding citizens. And just detail all the facts of the case. But however, in this instance, if you have to file reinstatement and if you're also filing a lawsuit, you don't want to accept any wrongdoing. In most instances, there's actually no wrongdoing. So when we're filing reinstatements, we are not really accepting any wrongdoing. We're simply saying that, look, this was a mistake. Looks like there's a administrative error on the part of the CVIS website. It's been cancelled for no fault of our own. We are good people, and we have good moral character, etc., etc. So please approve the reinstatement. That's what we're doing. We're not acknowledging any wrongdoing, just so that they can file a lawsuit if required, later on. So yeah, those are the grounds that we're filing reinstatement on.
Another question to Santosh sir. So far, is there any response from United States government in favor of students? And we know that you have filed a lawsuit in the state of New Jersey. So do you want to put any light on that, sir?
I'll probably have Vijay provide more details because Vijay, Josh, and Zimran, they are the ones who actually worked on the lawsuit. So Vijay, are you on the call? Yeah, Vijay, can you provide more updates on the lawsuit? I know we were trying to serve. Yeah, just go ahead and.
Pretty nice. And we're in the process of actually seeking an order to show cause right now so that we can get a preliminary injunction so that the court will issue an order while the actual litigation is pending, which can take a few months, that we at least have the court order reinstating the individual service, and so that the individual can continue to proceed on their OPT as well as any education that they're getting. So we're hoping that will be granted in the near future, very shortly. So it's very similar to the lawsuit that was filed in New Hampshire by the ACLU. We have very similar cause of action. I think we filed them simultaneously. We're just going with the preliminary injunction route. They chose to go with the temporary restraining order. Difference between the two: temporary restraining order is very temporary. It's only for 14 days. Then the court wants to get both sides to kind of make the arguments and then decide. We're going straight to the get both sides to make the arguments and then decide, so that way we don't have to have a 14-day window and then redo the whole arguments all over again. So that's where we are right now. We're hoping in the next 2 weeks or so we should have a ruling from the court. Obviously, if we do, we'll keep everyone posted on the updates on that. But if you certainly have any other questions, we'll be happy to answer them for you. But thank you.
Yeah. And just to add to what Vijay was saying, right? So we are planning to file next lawsuits. We'll be most probably filing in the DC District Court, wherein we'll be trying to do it more of class action because we have the option of either filing it in the district court that has jurisdiction over the plaintiff's place of residence, or we could also try to file it in the DC, right? So now we're next priority is to file most of these cases in the DC federal court itself.
The next question is Prashanti ma'am. I was on STEM OPT. My service was terminated. If I hire an attorney and fight and get TRO, will I get to go back to STEM OPT?
Yes, as Santosh said, if the lawsuit is approved and if the judge approves the case, then it's possible to go back. If the CVIS is terminated, then it should go back to where you were before the CVIS was terminated. So if you were on OPT previously, then you should be able to get back into OPT status.
Yeah. Just to add to this one, if somebody has filed both lawsuit and reinstatement, right? Once you receive a favorable judgment from the court, I recommend that you withdraw the reinstatement, because for reinstatement, you might have used a different I-20. You don't want to go to that go to the program based on that I-20. So you got to plan these two things properly.
Right. As Santosh said, the reinstatement can only be given based on a actual coursework. So you can't be on OPT and get reinstatement. So they give you a fresh reinstatement I-20, and they expect you to go back to school. So you're at that point you're giving up your I-20. So that's something to keep in mind. Giving up your OPT. So that's something to keep in mind.
Yeah.
The next question to Santosh sir. Hi, CVs terminated and visa got revoked due to selling in alcohol under 21. What is the best option to do and what do you suggest?
See, in this case, option number one that I discussed, right, which is going for visa stamping, right? That could be definitely be a challenge for two reasons. One is here the person is not only charged with selling alcohol to minor, but he most probably the person is also working without authorization. There are two violations here, right? So definitely their chances of getting a visa after the person has worked without authorization while on F1 is going to be very, 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 very little, right? With that said, yes, you always have the risk of not receiving approvals from on reinstatement or court order. But in this case, if they're willing to take the risk, I would probably file the case in the court and then also reinstatement, because here when you're filing it in the court, we are saying that hey, I don't know. It all depends upon whether the person has been convicted or whether the case was dismissed also. Have to look at the individual case to provide the exact advice. But if the case was dismissed, then I would recommend just filing it in the court here.
Question to Prashanti ma'am. While lawsuit is going on, can student file for H1B if selected on lottery this year? What would be my chances?
You can file definitely for a H1, but you cannot file for a H1 change of status since you don't have status to start off with, pending status. So you'd have to file for a H1 consular processing. And when filing H1, they don't usually look at whether you have a misdemeanor charge or anything. There's no question. They don't do fingerprints. So, usually filing a H1 and getting it approved is not an issue. Hopefully they won't start doing that. But as of now, they don't do that. So you shouldn't have a problem getting a H1 consular processing. And then at least you, that way you keep your registration intact, right? Because you can only file within 90 days. And after that, then you've lost your registration also. Keep your registration intact. And then if you're able to, if something good happens with reference to your CVIS termination and you're able to recoup your F1 status, then you can always, either file for a change of status again from F1 to H1 based on your previously approved cap exempt H1, or you can go for consular processing, depending on what your situation is.
And this question is for both of you, sir. Why you guys are not speaking or supporting temporary reinstatement order? Does TRO also takes long time?
Well, there are a few, receiving temporary restraining order is definitely a good option, but this has to be we have to litigate this matter in the court. First of all, we need to say how the courts are going to respond to each of these cases. We don't want to provide the information without a case. We could have filed all the lawsuits together, or we could do one after the other. Because we chose to do one after the other because we want to see how the response would be from the court. Right. Initially, we were even afraid of there was another challenge because we did not exhaust all the administrative remedies. That was one of the reasons why we were waiting for a couple of days to file this lawsuit. And then as soon as we realized, because now that it's an emergency situation, we had to go ahead and just do it. Right. Temporary restraining order, yes, it will help for a temporary period of time. It's not like this thing will be reinstated.
And it doesn't necessarily mean you ask for a temporary restraining order that you will get it from the judge. I mean, in the registration case, they asked for a temporary restraining order, but they were not successful in getting it with reference to the alien registrations, the requirement to register. But the case is still going on, and it has become law. So you have to start registrations now. And the judge didn't agree with the temporary restraining order. So you're not always successful there.
So the next question is, can they reinstate and go back to India and come back if they got civis back?
Who's that question for? Santosh or me?
Santosh?
Okay. So what is the reason to go back to India to apply for reinstatement if you're planning to go back to India? Because reinstatement, you're filing it so that you could continue to stay in the country, right? If you plan to go back to India, no need to file for reinstatement, no need to file for the lawsuit also. So for those people who are planning to leave to India, don't file any reinstatement, don't file for to litigate the matter in the court. Instead, just request for voluntary departure and go with that. We don't want you to unnecessarily spend money on litigating the matter and then also filing reinstatement in this case.
And also just to add to what, if you file
Yeah.
reinstatement, leave, there is no reinstatement. So you're just wasting your money.
Yeah.
Next
They'll
question
deny,
is from Daksh. Sorry, ma'am, you were saying something. Please go ahead.
they'll deny the reinstatement if you leave the country after filing.
Yeah.
Okay. The next question is from Daksha. It's for Prashanti, ma'am. Will getting a TRO from court for F1 OPT students reactivate their EAD as well and allow them to continue working until the case is resolved, which could take 4 to 8 months?
Everybody is very keen on this TRO thing. But yeah, if the judge, it depends on what the judge decides. If the judge orders for a restraining order, if he approves the restraining order, or if the judge approves the case, then, as I said, if you were an OPT before your CVS is terminated, then your status should go back to whatever status you had before the CVS termination. So if you are an OPT, you should be able to go back to OPT.
This question is for Santosh, sir. While lawsuit is going on, can a student, this is already repeated. Next question is from Tirupati, sir. I am currently on STEM OPT and unemployed with work authorization valid until May 2026. 2 days ago, I unexpectedly received an email from university saying that my visa has been revoked. What are my chances?
I think he is referring to service termination, because if it's the email from the university, then it's most probably service termination. So we discussed this question, right? So they have two options, which is one is to leave the country. The second one is, I don't know whether his service has been terminated because of him not maintaining his OPT status, because you mentioned that he has not been working. So it all depends upon his circumstance, whether it's been revoked, whether his service has been terminated because of not maintaining his OPT status, or whether he has been charged with a crime.
Yeah. Next question is for Prashanti, ma'am. Will it be a problem now or future if we file a lawsuit against USA regarding this situation? Won't it be a problem now or in the future if you want to come back?
It shouldn't be. I mean, you have the freedom to, file a lawsuit against anyone. But I don't want to say much about the present government. But in general, it shouldn't be a problem, because you have the freedom to fight for your rights and ask for justice. That's what the courts are for. So it shouldn't be.
Even the lawyers are not safe, right?
Exactly.
Yes.
Immigration lawyers are most at risk.
Yeah.
The next question from Spandana. Could you please explain what if shoplifting, they convicted, plead guilty, and later they expunge the case? This question is for Santosh, sir.
Okay, so typically there is something called petty theft offense exception. Okay, so we never had this situation of service terminations for that reason before, right? So usually people used to receive visa revocations, and then whenever somebody's visa was denied for this reason, then we used to write letters to the consulate saying that, hey, yes, this happened, but it does qualify under petty theft offense exception, and she should not be considered as inadmissible to the country. And most of the times it used to go through, especially if it's only one crime, one charge, one misdemeanor that they had, right? But now in this administration, I don't know how they're going to look at it. Okay, so it's a tricky situation. But until like at least last month, we used to do that one. We used to use the petty theft offense exception. Prashant, you want to add anything to this one? Is there any other thing that you used to use for anyone charged with shoplifting?
Yeah, shoplifting, of course, can be a misdemeanor or a felony. If it's more than a certain amount of money in different states, it could be a felony. So that's presuming it's a misdemeanor and presuming that they've only had one offense, one misdemeanor, not multiple misdemeanors. And the only reason we had to use the petty offense exception is when you're filing for a green card. We never had to use it in any other circumstances, right? It's only when you're filing for a 485 adjustment of status where we file for a petty offense exception, and maybe when you're filing for citizenship after that. But even if the case is expunged, the fact of the matter is that there is a petty offense, even if there is no, I mean, even if there is deferred judgment also. And sometimes even if there's no conviction, but there is an arrest and you've said that you're guilty. You've admitted that you're guilty. Even a guilty charge is enough. But all these things are covered by the petty offense exception, as Santosh said, and we've never had any issues in the past. And I think the funny thing is, that the ICE is revoking these. Is terminating CVIS. ICE never terminates CVIS. There's a very limited circumstances under which ICE terminates CVIS, right? It's always the DSO that terminates the CVIS for, if they have, not maintained their status. Under DHS regulations, ICE terminates status only under very, very limited circumstances. The circumstances have to be really, really serious. And the regulation and in order to do that, there is a lot of paperwork, right? It has to be either there's a publication in the Federal Register of a finding that the termination is based on national security, diplomatic or public safety reasons. So it's like that grave. Now they're just terminating CVIS for petty offenses. And even for cases where there's no offense, where there's no proven, there's no conviction. So that's just ridiculous at this point of time.
Unless one of the judges has ordered has issued a restraining order or order to reinstate your status. So you don't have any other option but to leave the country immediately.
The next question is for Prashanti ma'am. Is it better to leave the country and re-enter with a new I-20 or apply for a reinstatement from within the US?
That's $1 million question. I wish I had the answer to that, then I would be a millionaire. Because I would give correct answers to everyone who calls me, and then, but first of all, there's no one answer. It depends on every individual case. It depends on why they got their CVIS terminated. But in general, if you expect that you can leave the country and then get a visa from outside the country in today's circumstances, especially if you have some kind of even an arrest or a charge, and even though there's no conviction, I think that's difficult. In the past, I would have said yes, because there are many instances in which people's CVIS has been terminated for various reasons. They went back and got a visa and came back, no problem. Even in instances where the visa was revoked and because there was some felony, not a felony, but a misdemeanor, a DUI or something. There are many instances in which they go to the consulate, they go through 221G, they ask them to take a medical test, they do a drug test, and then after all that is resolved, there are many instances where they got the visa. That's under normal circumstances. We're not living in a normal world anymore. So I am very skeptical about them getting a visa after they leave. I'm worried for them if they leave and come back. But then, what is their chance? It's in between the pan and the fire, right? Between the frying pan and the fire. That's their option here. Either they have to do reinstatement, which is again very difficult to get in the present circumstances. So I think litigation is my only hope at this point. It seems like the best option, or the option where at least an independent body is making a decision, right? Even an immigration attorney, they don't seem to be making any independent decisions right now. We've seen that. But I think the best option is litigation, really, if you're able to litigate and if you have the stomach for litigation and you're able to not get arrested by ICE in the meantime. And of course, that's a risk that you're taking, and getting detained and worst, getting deported to a third country. That's really a risk that you're taking, and so you have to know what the risk is, what the worst case scenario is. Santosh, if
Next
you want to add.
question.
Yeah, actually, I agree with you on 100% on this, Prashanti. But just to add to that, add to this one, right? So I have been advising clients who have been incorrectly charged, because there have been situations wherein maybe there was a small domestic violence case, and in some states, the police has to arrest one of the parties, right? And then immediately the case gets dismissed. So it's pretty much a frivolous case, right? Or in situations where the person was fingerprinted for unknown reasons, like, or for example, like we had a case wherein one of the person, she lost her passport, and she went to the police station to report that she lost her passport, and she was fingerprinted for that reason. Even her service got terminated, right? And in cases like if it's just a reckless, or if it's a very, like, depending on the severity of the crime, and if they have the option of actually if traveling back to India, not everybody has that option, of course, because some people might have taken loans and all that stuff. But if they have the option of traveling back, and then if the crime that they have been charged with, whether if it's dismissed or if it's very, very, very minor, then I'm recommending on them to go back to the home country, go for stamping, instead of having to worry about whether ICE is going to come detain them, or whether their service will be reinstated and all that stuff, because they'll be wasting a lot of time on this one, worrying about all the stuff. And that's their precious time that they'll be wasting, right? So, and if they cannot travel, if they're not willing to go back to their home country, then I'm suggesting them to file for reinstatement as well as litigating the matter in the court. The other problem is in case, because we have had a situation wherein the ICE official went to one of the students' home 4 to 5 days ago. Okay, this is the only case that we have seen so far wherein ICE official actually went to the student's home. When we spoke to the officer, he mentioned that as soon as the student's service is getting terminated, they have been notified of this termination, right? And they're just waiting for some of the students to leave. Right. And if they arrest it, they detain any student, they'll be charging them with 230 section INA 231A1C1, and instead of issuing them the notice to appear in front of the judge, they're actually detaining them directly and putting them through the deportation remote proceedings. So if that happens, then the chance of coming back into the country will be very little, right? So that is the reason why I'm suggesting that if a person is being charged with a very minor offense, or if the case has been dismissed, then I'm suggesting that it's worth, maybe it's worth for them to just leave the country. Because once they are put through a deportation, they'll have to spend maybe at least a few months in the detention center before they can even request for voluntary departure.
Unless they agree to
I'm not trying to scare anyone, but that's an option that is available, and especially for a person who doesn't want to take any risk, I would suggest leave the country.
Yeah. Unless they they have expedited removal, then hopefully they'll won't be detained.
The problem is we had the same problem during Farmington University issue also. Doesn't matter, like, because first of all, the court dates will not be there most of the time, and especially we will not know whether they will be and there have been situations where they transport these people from one detention center to another detention center. So by the time we go and file a lawsuit in that particular court, they'll be moved to a different detention center. So it'll be a nightmare. And as you know, like, we have experienced this during the Farmington issue itself, and the students are not used to that kind of environment. Right. So the gravity of harm is very high. So I don't know if I were to be in their shoes, if the crime is like very little, or like whether if it's been dismissed, I would just go for stamping. Again, that's my personal opinion. But yeah.
Much time. So I think we need to be a little faster to address all the questions.
Okay, sure.
Gopal.
Yeah. So next question is from Pramod Nalavelli, sir. Many law firms are filing lawsuit. Some of them are saying class action. How this works? If we are not a part of this lawsuit, we get relief applied to the same class. Santosh, sir.
Good. So usually what happens is, once we have a precedent in the court, right, we could reuse it. So usually what we are trying to do is we are trying to come up with class actions involving people of certain category. For example, first we'll look at one set of candidates who do not have any convictions, right? One set of candidates who have been charged but with very minor crime. So we will be categorizing them into different categories, and then also based on their location, right? Based on where they live. So we'll have to categorize them into different lawsuits, right? The good thing about the court system is, once you have a precedent from one judge, right, you could try to reuse the same thing. Like, for example, if the judge has issued an order saying that, hey, this class, right, should not be we should be granting reinstatement for this class, then we can when we submit the next set of petition, we'll try to mention that, hey, the judge has previously ordered so and so, right, and then we request you to please issue the same order. The courts will try to be very consistent. Okay, so here the other issue is, I'm sure like this court will be these cases will go to the Supreme Court at some point of time, and I'll not be surprised if it goes to Supreme Court in the next few months. And if there's an order from the Supreme Court, that will help everybody. Prashanti, you want to add something to it?
I agree.
Next question to Prashanti. Oh, sorry. Go ahead, sir.
The steady stream of questions. When you get a chance, there are a lot of parents in India. They have spent money to send their kids here, their children here. So anytime, if you can give them some assurance, something, any message to the parents that are watching from India, what can they do? They're very concerned, about the future of their children. So I just quickly, I want to, when you get a chance, when you get a break, please address them. Do we know when a TRO, anybody has applied for a TRO? Has either of you applied for a TRO? It looks like if one TRO is issued, that could be the basis for multiple other TROs.
So right now, these are issued by individual district court judges, right? Just because one district court judge has approved it does not mean that the other district court judge would also agree with the same, right? So unless it is coming from a higher court, it could be a challenge.
But I guess to Jay Garu's question with reference to message to parents, and I think, what we're talking about will encompass all the questions that we're going to answer, because this is basically what is on everybody's minds anyway, because this is the basic question. What do you want us to do? Of course, we can't make the decision as to what you should do, but it depends on a case-by-case basis. I would be very worried if I was a parent, same situation. So I completely. This is not going to last forever. This is a temporary thing. Unfortunately, some people are caught in this temporary web of events, right? It's not going to be like this forever. It's going to be like this for the next few years. And maybe not even the next few years. I'm just trying to look on the positive side. The present government tries to throw everything and the kitchen sink, into the whole turmoil and see, what catches. So they try to throw everything into the mix and put as much effort into it. But finally, what ends up happening is what the courts decide, right? So maybe, as Santosh said, in the next few months, if we get a decision from the Supreme Court, everything will be back to normal, is what I'm hoping. Like we saw with the tariffs and we saw with other things, things are going up and down. So I wouldn't lose hope right now. I wouldn't give up. I would wait and see. I think the wait and see approach is the best approach right now. Even for parents out there, of course, you have to be cautious. Kids have to be cautious. Stay under the radar. But I would, again, say this, of course, with caution. But I think wait and see approach is a good approach to have right now because things might be positive. I'm hoping they'll be positive because there's no rule of law here. There's nothing on no basis that they're terminating CVIS. So if we look at the rule of law, if we look at the Constitution, they have no basis for doing this. So that's why I'm hopeful that the courts will turn this around. And they've shown that they've done it in the past. So I'm hoping they'll do it again.
Yeah.
So yes, we are receiving most of the calls starting a couple of days from the parents too, sir. Like asking how safe are their kids here? Do they have to come back to their birth country, or do they want to be here, running around, or staying at their cousin's place, friend's place, or getting out of ICE? So, what is your suggestion on that, sir?
Well, first of all, the parents have to support their children. That's first thing, because when we do a lot of consultations there, the students are like, my relatives are thinking that I did some crime and all that stuff. So just because somebody's service got terminated, please do not think that they did commit some crime. Okay. Second thing, the students have to be very vigilant because we cannot advise as to what they should do, how like whether they should hide from ICE or whatever, but they have to be cautious. Right, they have to be cautious and they have to work towards getting their service reinstated if they are trying to be in the country. Okay, the sooner that they're able to get the reinstatement done, the better it is. But other than that, they have to be vigilant. Just make sure none of the ICE officials catch you, whatever reason. Right, and don't get into any sort of trouble because now, especially like the few of the police departments are actually signing an agreement with ICE wherein they can actually deport a person directly once they have been released from the jail. I think Loudoun County also has signed such agreement in the recent past.
Prashanti ma'am, I have a question for you from Ritvik Reddy. I was involved in an accident where I was not at fault, but during the accident, I did not have full license. So I got my points on the DL, went to court, received money because I was not at fault. How will this affect my service?
Well, it looks like your service has not yet been terminated, which is good news. And looks like maybe it was just a traffic violation. It was not actually a crime. Again, I want to tell students out there who are listening that it's very important you hire both a criminal attorney and an immigration attorney if you've been arrested or if you've been charged with a crime. 99.9% of the people that I've spoken to have thought that it was a traffic violation. It's not a big deal. I just had to pay a fine of $300, $400. They didn't even realize it's a crime in most instances. They just thought traffic violation. So there are instances in where their insurance was expired and they drove with, insurance expired. They thought it was a violation, and they gave me the number and they gave me the state, and I'm like, but that's a crime. In Arizona state, that's a crime. So please do not presume that you know the law. Please talk to experts. Don't plead guilty to anything unless you've spoken to both an immigration attorney and a criminal attorney. Very important. And students often, I'm telling you, they don't realize this. They just think that they're getting off easy because they're paying a fine and they thought they'll have jail time, and they're just very happy that they don't have jail time. And they don't realize that this can have consequences, until they get their citizenship, for jobs, for immigration, for everything. So that's one thing that I, definitely wanted to bring to your notice. But in this instance, it looks like it's a traffic violation. Please look at it and look at your charge sheet and see what you've been charged with. Speak to a criminal attorney, speak to someone, speak to an immigration attorney, and see what the charge was for. If it was a criminal offense, then I would say change status now, before you get a serious termination. If it wasn't, then I think there's nothing to worry about. If it is. But of course, we have seen that people are getting serious terminations for no reason also. And I was reading today that even some immigration attorneys are getting emails saying that, you should leave the country, blah, 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 because they're getting confused between the
Fine.
client and the attorneys. And sometimes the attorneys' emails are given in some instances, so they're sending emails to the attorneys as well. So that's, just interesting to see, with what kind of preparation they're sending these emails. Obviously, they're just mass emails that are being sent out, through some system, mass service terminations. They're not pricking on a case-by-case basis. So, just something to see that it's not being done in an organized manner. But I would say speak to an attorney just to make sure that it's not a crime.
Question to Santosh sir. As we know that you have filed a lawsuit, how can we be a part of it? And if you get a positive response for the lawsuit, which was filed already, still can we be a part of it?
Yeah, so basically we will soon be filing another set of lawsuits, but we will be publishing, we'll be requesting the information sometime next week. Once we decide as to which court, how we're going to do it and all that stuff. So we'll probably make a decision sometime next week, and then soon after which we'll start accepting clients for filing the lawsuit. So we will be posting a notification regarding that sometime next week.
Prashanti ma'am, recent argument by ICE in a court for a TRO posted by an attorney. Revoking service does not end legal status. Does it mean if F1 is valid but service is terminated, legal status is still on?
So there is two different understandings here. One is, of course, your service is terminated, so you're not in student status. But does that mean that you're in removal proceedings? You're not in removal proceedings until notice to appear is issued by ICE. Until then, you're not in removal proceedings. It could be that unlawful presence starts accruing. That's, of course, questionable whether it does or not, because maybe it doesn't, because as per the original regulations, if you're in DS, duration of status, student status, your unlawful presence doesn't start accruing until USCIS has said that you're out of status. So simply a service termination does not mean that you're out of status. If you get a denial, or if you get a letter from USCIS stating that you're out of status, then or if you're in removal proceedings, that's when unlawful presence clock starts ticking. So that's one point. The other thing is, as I said, until you are in proceedings, until you get a notice to appear, you're not, for that purposes, you're not in unlawful, you're not in removal proceedings. And the next thing is, since the student status is decided based on not an I-94, because there's no I-94 end date for a student, it's based on duration of status. So if your status has been revoked, in that sense, you're out of status. So I think what they were arguing is that they were not in removal proceedings, but they're out of status for the purposes of, for duration of status is what I'm thinking. Because the CVS has been terminated and they're no longer in student status.
Yeah.
And the same way, they cannot file a change of status because their CVS has been terminated. That indicates also that they're out of status.
Yeah. And just to add to what you mentioned, Prashanti, based on the information that we received from ICE like last week, they mentioned that they're no longer issuing NTAs. They're directly putting them through deportation instead of issuing NTAs. I don't know how far, whether whether all the jurisdictions are doing the same thing or not, but the officer that we spoke to, he mentioned they're no longer issuing NTAs.
So even without going before the judge, they still issue an NTA.
Yeah, even before going before the judge, they're just charging them directly with 231 A1C1 and then putting through the deportation.
But the NTA is the charge sheet. No, without the charge sheet,
That's what he mentioned. This is something new. It did not. Yeah, that's why we were like surprised. I don't know. Is Zibran on the call? Gopal, is Zibran on the call?
No, sir. He's actually handling the consultation still.
Can you check if he's available? That will really help.
Sure, sir.
Because
Right,
Zibran
because
has been in contact with ICE official, and then they have suggested that we work with OPLA to see, because they are the ones who are providing all the legal advice to the ICE officials who are going on the field, right? So we are actually trying to work with them to see if we can get more insight into this one. But this is a scary situation if whatever the officer is telling is true.
right, because it doesn't seem.
Yeah.
Doesn't
Vijay,
make-
Gopal, did you join? Can you check?
I just checking, sir.
External Affairs or Indian Embassy, can they do anything? Can they talk to State Department? Hey, there is no real law against these students losing their service status. They have done minor petty crimes. This is a new thing. I think they started this because of the unrest in campuses when Palestinian and Israeli issues have come up, and this has gone too far, I think. Can the Indian government and embassy, ambassador, can they do anything?
So I'll just take this question first, Santosh, then you can add on. I was just talking to the Indian consulate in New York. So I was talking to the CG Community Affairs and CG Educational Committee, and I asked them the same question: why are we not, doing something with reference? Because most of these students are Indian students. And I reminded them, because these people keep changing every 5 years, they change, so they forget. But I reminded them that during the Farmington students' time, we actually went to the New York field office and spoke to the head of ICE at that time, district director, and we're able to get voluntary notice to appear. I mean, we were able to get bonds and release students from detention by representing by representation from in this formal manner through diplomatic representation. We were able to get them out on bonds. We were able to get expedited NTAs issued so that they can leave immediately. So there were a lot of things that we were able to do under the radar. And I think I've told them that it's inevitable. The same thing is going to happen. So we need to make sure that we're able to represent these students, if they get detained or if something happens. So we should go and meet with, the head district director, ICE, New York, New Jersey, because the New York represents like 5 states, I think. So they have said that they're gathering information and that they're looking into all the possibilities. The CG also is aware of it, and I was supposed to meet them this week, actually tomorrow, but I have to wait and see what happens. But I think we're definitely looking into what can be done on the ground to help these students. At least maybe if we can talk to ICE and say that, look, um, don't detain them, or preempt detention or preempt something like that, small things. Maybe for legal things, no, don't terminate service. Maybe that's not possible because that's a decision made on a higher level. But smaller things with reference to some flexibility with reference to detention, issuance of NTAs, maybe that can be done.
Very good. Thanks, sir.
So, Santosh sir, there is one question for you. Is it possible to litigate against USCIS or ICE if they have made an error or acted unfairly during these procedures?
Yes, definitely there is a chance, but how does it really help if they already went through all the trauma with ICE?
And can I file H1B while reinstatement is pending? Will it affect per approval chances?
Good. So for filing H-1B, they don't care about your current status, right? So here is what I have been advising my clients. So if they're filing H-1B, even though their service has been terminated, I'm still asking them to file with the request for a change of status, hoping that, and then parallelly, I'm asking them to file for reinstatement and litigating the matter in the court. That way, in case if their service gets reinstated, or if there is a restraining, if the judge issues a restraining order, their change of status from F1 to H1 could be approved. That way, they could avoid going for H1B visa stamping. But again, that is under the presumption that at least one of these two, either reinstatement or they will be approved, or the judge will issue a court order. Prashanti, do you agree with this?
I am basically just saying, look, file at least H1 consular processing. Then you can always file a change of status without having to leave the country later on. I mean, but there's no harm in what you're saying also. I mean, you can file H1 change of status, and if they approve the change of status, great. If something, I mean, if things are in their favor. Otherwise, at least they'll send an RFE and then approve the H1 for consular processing. Because they'll say the person is not in status. But the only thing, Santosh, in that is if they send an RFE and then you're bringing it to their attention that they're not in status, I'm just worried that it might affect their H1B filing also in some way. I just don't want to bring it to their attention that, that their service has been terminated.
Approve the H1B, right? At least for consular notification, even if they deny the change of status, they should still approve the H1B. Right.
The H1B, but you never know with this Trump government if they see that there's charges against them, and I don't know. I just don't, I'm just using a more cautious, but there's no harm in either way. I think both will work.
So the next question is for both of you. Are there any recent trends in RFEs for denials for students or H1B applicants?
You want to go first?
Yeah. So peculiar RFEs that we have seen in the recent past, right? Now one of the RFEs, which is little concerning, is so those people who have applied for a consular notification prior, right? For example, if somebody is on OPT and if they applied for H1B requesting consular notification, and now when we are filing for a H1B with change of status, recently we received RFEs in 2 cases where the officer mentioned that, hey, unless the person gets a visa stamping or they have had H1B status, they're not cap exempt.
Oh.
Okay, which is very scary. But good thing is on the approval notice itself, it says that the H1B is approved and then they can go for a consular notification, is approved, and that they're being counted towards the cap. So we did argue that one, and these cases got approved, but they were approved for consular notification, so they did not approve the change of status again.
Yeah, these H1B
cases. Yeah, this happened in 2 cases for us so far. I think Chand Parvatinini also had a similar issue.
I am worried about what is the definition of cap exempt and what isn't, because they keep changing that based on what comes into. So when we have to say whether it's cap exempt or not, the strictest interpretation that I've seen in so many years is that only if you start working on a H1 only, then you're cap exempt. That's the interpretation that I've seen in the past. Then, of course, they became very liberal with their interpretation. As long as you filed a H1 and got approved, they treated it as cap exempt. So this keeps changing. So you have to be very careful, when you're filing your H1 as to whether it's cap exempt or not.
Yeah.
Yeah.
And I highly recommend that the students who are filing H1Bs, try to stick with the employer for at least 1 year, because in case if the petition is revoked for fraud or misrepresentation, or if the employer withdraws the petition in the same fiscal year, there is a chance that their service could be terminated. There is a chance that their cap number could be reinstated. So if that happens, they'll have to go through the H1B lottery process again. So just be cautious with that one.
Zibran has joined, sir.
Good.
But I have a question. I was arrested for public nuisance. Case was dismissed for lack of evidence, but the judge asked me to do a community service. Does that mean there's a mistake, but judge left me easy? And continuation of that question, if I have a reckless driving ticket in my record with 1 year probation, is there a chance of getting my reinstatement approved? Question for
So,
Prashanti ma'am.
yes, but just before that, I just wanted to answer the question with reference to what we're seeing, new H-1B RFEs, etc. The new RFEs we're seeing, especially for these cap cases, they're asking for contracts, work orders, from all the parties, like they used to ask in the past. And they're saying very specifically from the date of filing, we need to make sure that you have work for those people. So, and it's again a big list of things. And also to prove status, they're asking to prove status from the time that they've been into the country, or they're giving a certain period of time. But a long, long laundry list of requirements, several pages, and they're asking for work orders and contracts from all the parties concerned. They're not, and in this instance, we did submit a PO and a contract. The contract and PO between all the parties. This is what they did in the past also, when they were talking about employer-employee relationship and all that before the IT serve decision. So they seem to be going back to that to a certain extent, and that's not good news.
So, what precautions should international students take while traveling in and out of the US during this time? Question for both of you, ma'am and sir.
Don't travel.
I guess
Don't travel.
don't travel. If you
So do
have
not travel in the sense of what, sir? Like if there is an emergency.
So especially in the recent past, about the situation that we have seen, right? Number one, don't travel through airports like Abu Dhabi, wherein you have a very little layover time and your port of entry is at Abu Dhabi. And then make sure you enter the country before your course start date, because I see that like we have two cases wherein the students try to enter, I think day after their course has started, like the semester has started, they were sent back. Previously, they were like that was not an issue, but now we have had two cases wherein the students were sent back for that reason. And make sure to pay the fees beforehand. Make sure to register for the classes beforehand. And if the officer, like there's a high chance that the officer might check your phone, make sure it doesn't have any incriminating information regarding off-campus jobs or anything like that. Do not discuss anything regarding off-campus jobs, or do not discuss anything about your resume, like resume alterations, whatever, right? Just be cautious with those things. Prashant, you want to add anything to that one?
So, I mean, it's very difficult to tell students not to travel at all. And then for how long will they not travel, right? That's another problem.
Yeah.
So I'm basically saying that if you have any issue, you've had any issue in the past, don't travel. But if you had a clean record, if your CVS was never terminated, you don't have any criminal history, please wipe out all your social media. Please don't send incriminating texts and no political opinions, no WhatsApp. Have a clean phone if you're carrying your phone. Don't carry your laptop if you can avoid it, or just, don't take out all the unnecessary information from there. And then you should be okay to travel. There are people traveling still and who have not had any issue. Most of them don't. But just be very careful. There is extreme vetting. And unfortunately, you might be the unlucky one who's been selected for, secondary inspection. So, you have to be prepared for that. But in general, be cautious. Wipe out all social media. Don't post any incriminating messages, and make sure you're traveling only if you have a clean record. And if you're not sure whether you have a clean record or not, and if you think it's like I said, traffic violation, check with an attorney before you travel.
So since Zibran is here, I want to know about his experience speaking with the ICE officer recently.
Good evening, everyone. Thank you for giving me an opportunity to join. So we recently had an encounter with an ICE officer when the officer was actually at one of the students' home. And we had an opportunity to speak to him. He was gracious enough to talk to us and explain the situation. he basically indicated that in the past, if someone submits a reinstatement or someone has a pending application or pending petition, as long as they show us a receipt notice, we would not make an arrest. We would not do anything to detain them. But now the rules have changed. And he was actually feeling kind of bad for students. He said, you know, I've been an ICE officer for 21 years. And generally we go after the bad guys. And it's unfortunate that we have to do this, but we have no choice. These are our instructions and we are following our rules and instructions. So now he indicated that even if someone has a reinstatement application pending or even a lawsuit filed, we still have to make the arrest. We still have to detain the individual and take them to IJ or ERO, and they will make a determination in terms of what to do, whether to go ahead and file unlawful presence case, or whether to put the person in removal proceedings. I explained to the ICE officer that the individual that he came to, the individual he went to in Texas, that individual's case was dismissed, completely dismissed. Like, not even a pretrial intervention or diversion program, completely dismissed. And he said, yeah, he realizes it. He realizes that the person's case is dismissed. He said he even knew that this person had actually purchased a ticket, to leave the country a few days before, but he never boarded the airline. And that's why, we're coming to check why he did not leave, or why he changed his mind. But he was gracious enough on that day to not make the arrest. We were able to show this ICE officer a reservation of a ticket for this individual to leave 4 days later. And that was the situation. But this officer was kind enough to tell me, or tell Santosh and I, that contact me if any emergency situation arises. I've been an ICE officer for 21 years, and I know a lot of people, and we will try to assist as much as we can, but we are also limited in terms of what we can do because the orders are coming from above. With that being said, I just want to make a quick statement, with the generalized statement. A lot of our students are getting in trouble not because they've done something terrible, or a lot of them are innocent. They're new to the country. They didn't know what the rules and regulations were. I'm not talking about students who've committed shoplifting or students who've got DWI. That's different. But a lot of them, innocently, we had one case where this student had a license from Illinois, active license, valid license, and he's driving through Indiana, and he gets pulled over in Indiana. The officers ask him for his license. He gives them the license. Of course, the license is Illinois license. The student is a resident of Illinois, goes to University of Illinois. The officer is like, well, you don't have an Indiana license. Well, sir, I don't live in Indiana. I live in Illinois. That's why I have an Illinois license. Well, no, you're supposed to have Indiana license. Makes the arrest, takes the fingerprint, tows his vehicle, takes him to jail, and next, the student gets a public defender's attorney because obviously he can't afford an attorney. Public defender attorney drops the ball, makes him plead guilty to having no possession of license, and now he's facing the situation of having his service terminated, visa revoked. I tell you guys, there's been a lot of discrimination. And there's a lot of discrimination going on. People are being targeted because of their race and religion. And it's terrible, it's a tragedy. And we as a community need to do more. You can't sit, because today is them, tomorrow is going to be us. That's just the way it is going to be. Thank you.
Thank you.
Thank you, Gibran sir. And the next question is for Prashanti ma'am. Will I face any issues during layovers or domestic flights while traveling back to India, especially at the airport due to my visa or service status?
Well, traveling back to India, no, if you're leaving the country, no one cares. If you're coming
Or
into
if you're
the
traveling domestically in here in US?
Uh, again, last Trump administration, everybody was scared of even traveling domestically. I remember there was a big hue and cry about illegal immigrants being caught at the bus stations, at Greyhound, and so people were even scared to travel by bus uh, for some time, and so people were not traveling even domestically because they were worried that at the airports also they will be required to report them. So people are cautious about traveling domestically also, but in general, nobody looks at your immigration status when you travel. You have to make sure you have a valid ID, and as long as you have a valid ID, you can travel. But if I was a student and if I was in trouble, I would lay low and I would not travel gallivant around the country, right? I would try to lay low.
And there's one more question, sir. In the recent times, we are hearing most of the H-1B and where the students who are coming from India to US are being asked a lot of questions. They have been scrutinized and they have been like terrified with questions like, are you been paying your employer to get the job or to get a training? So what are your suggestions to overcome those?
Well, first of all, you should not be paying your employer to file your H-1B, right? Also for the training. So if they have done that one, that means they did violate the rules, the law. So they could be subject to a lot of consequences. So as long as you don't you go through the right path, I don't see a problem. Right. So as long as they find a proper employer who is willing to file their H-1B without having them to pay, them pay any money, I think, and then if they have a job that is actually available, so they should be fine.
Prashanti ma'am, there's one last question for the day is Alien Registration Act. What do you say on that, ma'am? Because there most of people are confused with that, whether to go for the biometrics or who is eligible for biometrics.
Well, for most people, if you're in status and you've entered legally, it might not affect you in any way. If you're in status, you have to remember that if you have a child who's turning 14, then they might not have been registered or given biometrics at any point of time, even if they're permanent residents. So you have to make sure that if you have kids who are turning 14, then within 30 days of their 14th birthday, they need to register. Please make sure they do. You can go to the website, just Google it, and there's a USCIS website, and there is a form that you have to fill out. And then they will send you for fingerprinting to local office. And then you can get your fingerprinting done, and then they'll give you a receipt saying that you're registered. If you're out of status, then yes, you would need to get registered as per the law. It's a catch-20 situation, of course. But yeah, if you're out of status, most probably you've never been. If you turned out of status after coming to the US, then most probably you've been registered, so you don't need to. But if you entered illegally and you were never registered while coming into the country, then most probably that applies to you as well.
Any update on that, sir? Santosh sir?
Whatever Prashanti mentioned, I think she covered pretty much most of it.
Okay.
Then there's also, I guess, a lawsuit which was filed. And unfortunately, as I was saying earlier, the judge did not put a restraining order on it. So it continues, started on April 11th, I think. So until the judge makes a final decision, you have to go register if it applies to you.
With this, we covered most of the questions. So thank you, Santosh sir, and thank you, Prashanti ma'am, for being here. And I'll pass on to Mr. Jayant Chella.
Yeah, thank you. Again, it was a great discussion, very interesting answers, very good questions and very good answers. It's very heartening to hear some of the cases where these kids had no fault of theirs. They were fingerprinted. Somebody driving through Indiana without because of the police officer's ignorance. He was fingerprinted. Now he is penalized and he has to leave the country. So there are many instances. Very sad to hear these instances, but thank you both, Prashanti Reddy and Santosh Somi Reddy, for your valuable time and helping the community and helping the students. And people who are watching, if you have questions, please reach out to us, to ATA. On our ATA website, there is a contact information for Seva activities, 1-844 ATA Seva or ATA Help at ataworld.org. Please reach out to us, and we will be able to connect with attorneys and other community leaders. Thank you. Thank you, everyone. Narsimha, anyone wants to have any final?
Jayant Garu. Yeah. Before we close, I would like to, on behalf of ATA Student Service Committee, I want to thank our executive committee, our entire board of trustees, particularly Anil Bodhiredi Garu, Sharda Singh Reddy Garu, education committee Sushil Chandra Garu, and Secretary Sainath Boyapalli Garu, Naveen Garu for the live streaming. And last but definitely not the least, our President Jayant Chella Garu for encouraging us and helping us with setting up with this call in a short time. And we would like to thank all the participants for all your thoughtful questions and amazing speakers, Prashanti Garu, Santosh Garu, Vijay Garu, Gibran Garu, for taking time away from your busy schedule and providing with all your valuable insights. And again, the recording will be available on YouTube and all other ATA social media handles. Please share with your friends and family who you think might benefit from this information. And again, for any sensitive cases where you could not discuss your situation in this open forum, I'm sure Prashanti Garu and Santosh Garu will be able to assist you in any way they can. Please reach out to them. And stay strong. And yeah, this too shall pass. Have a great day, everyone.